This is Larry Jordan, the host of the Digital Production Buzz. The following interview is an excerpt from a recent program. To hear the entire program, visit digitalproductionbuzz.com. Jonathan Handel is an entertainment and technology attorney of counsel at Troy Gould in Los Angeles. He's also the contributing editor on entertainment labor issues for The Hollywood Reporter, and he has a website at jhandel.com. Hello, Jonathan. Welcome back.
Larry, thank you for having me.
Jonathan, well, wait a minute. Jonathan, you're sitting at your desk, and I still have dreams of that poor Porsche that you crashed. What's the status of your Porsche?
Well, you know, the Porsche was really just a radio-controlled car. The actual car that I drive is an SLK, so I brought it with me.
I will never forget the Mike's and my expression as you drove that Porsche into a cat dish. I swear, one of the highlights of the buzz.
It was a water dish, that's right.
Jonathan, there's an issue we're all wrestling with, which is how do you know if someone is an employee or an independent contractor?
Well, it's a tough one, and that issue has come up in no less than 3 recent cases involving Uber, which I suppose you'd like me to talk a little bit about.
I do, because the question I've got before we talk about Uber specifically is, why is the issue of independent contractor versus an employee important?
Well, that is the threshold question. It's important for anyone who produces or runs a crew in any way in our business. And it's important because it makes a difference in terms of issues like liability, taxes, withholding, potential for unemployment compensation, benefits, the need for sometimes to pay employee expenses, like when they use their car or their equipment. So there's a whole host of issues that revolve around whether someone is an independent contractor or an employee. And it's easier to treat people as independent contractors. That's what people tend to do when they're operating fast and loose, but it's not always the safest thing.
All right, well, let's switch over to Uber, which is setting the precedents in this case. I think you said there's 3 cases. Set the scene. What's the first one about?
Well, the most recent decision that we've had comes in a class action lawsuit by Uber drivers against Uber, drivers who want to be classified as employees, despite the fact that Uber has been classifying them as independent contractors. And what the court decided, much to Uber's dismay, is that case can proceed as a class action. So they've certified the class in the legal jargon, and the case is going to move forward. We don't have a decision yet, obviously, at this early stage as to, or even any indication as to how the court will rule on the ultimate question, but it is an important case. So that's number one.
Well, let's just take that just for a second. If the case goes to trial and if it's decided that they are employees, from the point of view of the drivers, what is the difference?
Well, there are several differences. One is that they have to get paid at least minimum wage. And so you start to have the question of, well, gee, when is an Uber driver on duty? If they've got the app on, and what if they also have the Lyft app on? Do they have to get paid? And let's suppose it's a really poor day, so the number of fares they have doesn't add up to covering minimum wage plus overtime for the time that they've worked. Who's responsible for that? Is Uber going to be responsible for topping them off, bringing them up to minimum wage? Is Lyft going to be partially responsible if they also are a Lyft driver? You can see the complexities. Expenses, the expense of using your car. When you're an employee, you're generally entitled to have that expense reimbursed at a rate that the IRS sets, typically or today around 52.5 cents or something a mile. Whereas an independent contractor is responsible for all their own expenses unless their contract says otherwise. And liability, and I should say liability is an issue as well. If an Uber driver in the rare instance commits an assault or something against someone, to what degree can Uber itself be held liable depends in part on whether they're an employee.
Okay, now there's 3 cases that you've described. The first one, which is the class action suit. What's the second one?
The second one, where we also had a recent decision, was a California Unemployment Appeals Board case. The Unemployment Appeals Board does pretty much what its name sounds like, which is if you're denied unemployment or if you're granted unemployment, whichever side is unhappy, the employer, the employee can appeal. And an Uber worker, an Uber driver, was granted unemployment by the Unemployment Appeals Board. And of course, to be granted unemployment, you have to be categorized as an employee, not as an independent contractor. So they made a decision on that same issue. The third case was before yet another body, the California Labor Commissioner. And there, the employee was seeking back wages, potentially overtime, I'm not sure, and also her expenses for driving the car. The commission decided that she was an employee and granted her the expenses. Didn't grant the wages, but that was really because the employee was uncooperative in providing evidence. So it's not a, it's not a decisive factor. Uber, I believe, is appealing that case. The unemployment case, I'm not sure what the status of that is. But what you see is sort of a trifecta of California cases, all of which have been, have gone against Uber on this issue.
Okay, so Uber is not necessarily making films on a regular basis. How much of this can be extended to filmmakers as they're hiring? Because we hire freelance people all the time. And if it applies to us, then what criteria do we need to use to determine whether somebody is an independent contractor, a freelancer, or an employee?
Well, it's a tough issue, and part of that is illustrated by the fact that although Uber has been losing in these California cases, they've won in other states that apply ostensibly pretty much the same rules. And the reason there's so much uncertainty on this issue is that there isn't a single decisive factor. There are something like 20 or more factors, or up to 20 or more factors, that courts and administrative agencies can look at in trying to decide, is someone an employee or an independent contractor? Among the key issues are the following. First of all, if you do in fact decide to pay someone as an employee, that's pretty dispositive. They'll be treated as an employee, but that's sort of the easy case. Set that aside. If you treat them as an independent contractor, it doesn't work the same way in reverse. It's not necessarily dispositive. They can get reclassified, as the Uber cases show. And the issues include how much control do you, the boss or the person engaging the worker, how much control do you exercise over them? Are they exclusive to you, or do they work for other people during the week doing the same sort of stuff? Do they train themselves if training is needed to do what they're doing? Do they bring their own equipment, or do you supply the equipment? Are you judging them basically by the quality of their work output, or are you judging them based on the number of hours they're working and the exact details in the way they're working? So if you're controlling, well, no, I want you to put a such and such filter in front of that lens, not a so and so filter, as opposed to saying, I want something that's sort of a hazy retro look. Those kinds of factors could help make the difference. So you can see it's not an easy call, but the more someone feels like an employee, the more someone is on your job, is at your job site, where you tell them, when you tell them, working primarily or exclusively for you, and not holding themselves out to the general community as available for services, the more they may have to be treated as an employee.
So short term, while these cases are wending their way through the California legal system and all of its different implementations, do we need to change our behavior in hiring freelancers, or do we need to protect ourselves with different contracts, or what should we do?
Well, that's hard, because on the one hand, you want to say, well, I'm a small operator, I'm a small producer, let's say, I'm doing small productions, no one's really going to pay attention to me. And it's true that, if you're not, 20th Century Fox or someone, or Uber or someone big, there isn't going to be the motivation on the part of the agencies to come looking for you. But one disgruntled worker, on the other hand, can create an awful lot of dismay and headache if something goes wrong. And then you are caught in the maw of a system that's going to decide, are they or aren't they? And you're tempted to say only their hairdresser knows for sure, are they an employee or not? Certainly in contracts, something that a producer can do is include arbitration provisions, because you can take the decision-making power away from the courts and many of the various agencies by requiring that disputes be arbitrated. And in fact, Uber somewhat belatedly did exactly that. And so that class action lawsuit we were talking about only affects and only applies directly to drivers up through, I think, 2013 or so. After that, drivers were signing or clicking yes on, I suppose, arbitration agreements in their contracts. So it becomes a very different look. An arbitrator is in general probably more management friendly, more company friendly, to be direct about it, and certainly less bound by some of the details of the law in some cases.
Well, it looks like we're going to have to keep an eye on this because there's no specific action we can take. We just need to be sensitive to it until the courts rule, which gets me to, go ahead.
Yeah, no, I was going to say that's exactly right. And, we saw something similar with the unpaid internship issue where people have been using unpaid interns, perhaps in ways that don't comport with the law for many years. We saw a court decision that put everyone on notice, and then that decision got reversed. And now it appears that some of the changes that the big studios made, they might not even have had to make. So there's very unsettled areas of the law here, and very politicized. Whether you're a Democrat or Republican, you've got your particular opinion on this, whether you're management or labor. And the judges are influenced by who they're appointed by. The politicians are influenced by who they're elected by. And it's not an area of law that just is as cold as as a piece of marble. It's not obvious.
Jonathan, I know next week you're going to be going up to the SAG convention. You're going to be giving us a report from that, so I can't wait to talk to you. But for people that want to keep track of you, what website can they go to?
They can go to jhandel.com or thrlabor.com, the Hollywood Reporter Labor.com.
And Jonathan, thanks for joining us today. If you'd like to see more videos like this one, please subscribe to our YouTube channel. To stay connected and receive updates from The Buzz, sign up for our free weekly newsletter now. Or you can learn more about us on our website. And thanks for watching The Digital Production Buzz.